Mr. Mason, when the fake Drake song was released on streaming in April of 2023, the public quickly discovered that this wasn't the long sought-after collaboration between Drake and The Weeknd, but an entirely new AI-generated song. I understand that his studio was able to file a notice and takedown under the DMCA because a small portion of the song was copied from an earlier Drake song. If the song had not contained copyrighted material, would Drake and his representatives had that same recourse?
Currently, no, they would not have. It was taken down because there was a sample.
So what, if anything, do you believe this incident says about the need for legislation?
It's opened the door to what's possible. It's shown the power of AI when it comes to voice modeling, when it comes to potentially deceiving fans. What we believe is that artists, creators, people who make music and make art should have the ability to approve or have some oversight into how their voice and likeness is being used. There should be an accrediting process so that consumers can understand what it is they're listening to. I want to know, is that the real Drake? Is that not the real? And an artist should also be remunerated properly when their voice or likeness is used. And for us, it really comes down to choice. If an artist would like to participate in creating music through AI or allow others to utilize their voice, we believe there should be a choice, and some will want to do that. As Lainey said, there'll be some that would rather not. But as long as they're credited properly, they have certain approval rights, and there's a way for them to be paid fairly, we see that as a possibility.
Thank you. Professor Rothman, you have testified that any federal right to a person's voice or license must not be transferable away from that person. In the context that was just described by Mr. Mason, how would that assertion line up with what he just said?
So, first of all, I think there would be a claim under current law, including under current federal law, if someone circulated a song and claimed that Drake and The Weeknd recorded it, as they did. That violates the Lanham Act. They have trademarks in their names. It also violates federal false endorsement law. So they would have claims, and those are all exempted from Communications Decency Act Section 230. So it wouldn't even go through the DMCA takedown provision. So it would be quite straightforward. In that regard.
I'm really wanting to know, though, about the transferability of a person's voice or likeness. Mr. Mason said that the artist should have a choice, and you're advocating for, I take it, a ban on a person being able to transfer their rights to their voice and their likeness.
That's correct. I don't think that should be allowed. And this doesn't mean that they can't make money from licensing their voice or likeness in limited contexts, but it means that we shouldn't allow people to transfer their voice and likeness and performances in perpetuity or even in very broad contexts, because this goes against all of the concerns we've talked about, which is deceptive performances where people can't tell whether it's real or not, and even the protections in the No AI Fraud Act that suggest that you need a lawyer. Well, if you take a young, aspiring artist, they may be able to get a lawyer, but they're going to have trouble paying for it. They're still going to have the same bargaining power, and it's not the sort of thing that we allow people to sell
young artists
forever.
Typically don't have good legal representation. I think first deal that gets signed, and that deal could include language that transfers to the recording company or the motion picture company the right in perpetuity for your likeness and your voice, that kind of thing, just in that first contract. So I think there is some danger right there, and I think, how would legislation look that would prescribe the transfer of voice and likeness rights?
Thank you. I've thought a lot about this because I think that's exactly right. The initial recording contracts will likely include those provisions. The NCAA has tried to include those provisions for student athletes. So this is a real opportunity for federal legislation to make clear, even under state laws, that this is not permissible. Now, how would this, and it could be prohibited such that the only person who would have this right is the actual identity holder, the person themselves. Now, that doesn't mean that you couldn't draft something that provided, for example, to record labels standing to enforce the use of a person's voice or likeness in a specific recording that was AI generated during the terms of a recording contract with the record label. It's very common for people with exclusive licenses in a variety of intellectual property contexts to have standing to bring legal claims. So I don't think we need to allow wide transferability in order to protect those interests.
Thank you. My time